We have great news today. The U.S. Department of Homeland Security, DHS, announced a new program to allow nationals from some of countries to skip the line to enter the United States ahead of all other green card eligible aliens who are waiting for an immigrant visa or green card to become available. In this video, we will explain this new program in detail to understand the process.
Visit our Swat&Vee channel with your questions to see how best we can help you out with your process. Please don't forget to subscribe if you're new to the channel.
Now let's get into the video and find out what the latest updates are on U.S. immigration. The Department of Homeland Security, DHS, of the United States made an announcement that it has established a new parole program to permit nationals from 4 countries to enter the United States ahead of all other green card eligible aliens who are required to wait outside the country for an immigrant visa to become available. This program will allow the nationals to skip the line to enter the United States. The term family reunification refers to the process through which citizens of Colombia, El Salvador, Guatemala, and Honduras are brought together again after being separated. The Department of Homeland Security, DHS, predicts that as many as 73,500 foreign nationals, 32,600 Salvadorans, 17,400 Colombians, 12,800 Guatemalans, and 10,700 Hondurans may be eligible to be paroled into the country and get work authorizations as a result of this program. Nationals of these countries must demonstrate that they are the beneficiaries of an authorized Form I-130, Petition for Alien Relative, in order for them to be eligible for consideration under the new process. This need is in addition to the specific eligibility criteria that have been established by DHS. That is to say, they have been placed in the queue to be considered for a green card based on their familial ties, but they will no longer be required to wait in their home countries for one to become available. This program is based on the precedent that was established by the Bush and Obama administrations, which established similar unauthorized parole programs in 2007 and 2014, respectively, to allow nationals from Cuba and Haiti, respectively, to be paroled into the United States if they had approved Form I-130s, establishing valid familial connections to United States citizens or green card holders. This program builds off of the precedent that was established by those 2 administrations. When a beneficiary submits a Form I-130, their place in line for an available green card is established. However, this does not guarantee that the beneficiary will be granted. Because the number of green cards that can be issued each year is subject to numerical limits, caps, imposed by statute, the majority of people who are eligible to receive a green card must wait several years before they can enter the United States. Under the overall limit, there are numerical caps for specific categories, such as the siblings of adult United States citizens or the unmarried adult sons and daughters of permanent residents. The annual limit for family-based categories is dependent on the immigration levels of the previous year and is set at a minimum of 226,000 visas. This program, along with other similar parole programs that have been instituted by the Biden administration since January 2021, is inconsistent with the language and history of the parole statute. This statute has afforded DHS increasingly limited authority to parole aliens into the United States on a case-by-case basis for urgent humanitarian or significant public benefit reasons. This program, along with other similar parole programs, is in violation of both of these provisions. This claim is contradicted by the program, which lays out specific eligibility requirements that applicants must meet in order to participate in the program. These requirements define a class of people in a legislative manner rather than describing general DHS officer discretion. While DHS does claim that each parole grant will be made on a case-by-case basis, the program contradicts this claim by laying out specific eligibility requirements that applicants must meet in order to participate in the program. The Act does not define urgent humanitarian or significant public benefit, and the Secretary of Homeland Security has traditionally been responsible for interpreting the statute in accordance with their historical understanding. Traditionally, the Department of Homeland Security has understood urgent humanitarian reasons to include urgent medical, family, and related needs, while significant public benefit has been understood to refer only to circumstances involving persons of law enforcement interest, such as witnesses to judicial proceedings. DHS argues that the program is justified as a significant public benefit, however, by furthering the U.S. government's holistic migration management strategy, specifically, 1. Promoting family unity, 2. Furthering important foreign policy objectives, 3. Providing a lawful and timely alternative to irregular migration, 4. Reducing strain on limited U.S. resources, and 5. Addressing root causes of migration through economic stability and development supported by increased investment. Notably, these factors would not be relevant to any one alien in particular. furthering a case-by-case judgment, but rather would apply to a whole group of persons in general. According to the Constitution of the United States, the full power to control immigration lies not with the executive branch but with Congress. Entry under parole is an alternative to a visa for wide types of aliens, such as aliens who have family in the United States and who may one day be eligible for an immigrant visa, has been specifically not permitted by Congress. This includes aliens who have relatives in the United States and who may one day be eligible for an immigrant visa. Additionally, merely having an accepted Form I-130, Petition for Alien Relative, does not guarantee that an alien will eventually be granted a green card, even if the petition was for the alien's relative. In order for the alien to be able to submit Form I-485, application to register permanent residence or adjust status, they will first need to wait for a visa to become available. If their application is denied by us as for any of the many possible reasons, the alien will have wasted their time. The introduction of this program is yet another approach that the Biden administration is utilizing to conceal the data that is at the root of the vast illegal immigration issue that is currently taking place in the United States. The Biden administration will be able to further reduce the number of aliens apprehended between ports of entry that DHS reports each month while still allowing large numbers of inadmissible aliens to enter, remain, and work in the United States without a visa. This will be accomplished by granting parole to aliens entering the United States from these countries, which in recent years have accounted for large percentages of border encounters. In the program announcements, the Department of Homeland Security, DHS, said that parole will be granted for periods of up to 3 years, but they stress that immigrants paroled into the United States under this program may request additional periods of parole once their current parole period has expired. It has never been the intention of the United States government to allow parole to serve as a legal foundation for long-term residency or employment in the country. Because of this, parole is not considered a lawful immigration status. Parole, on the other hand, is a form of temporary permission to enter and remain in the United States for certain activities that are only temporary in nature. According to federal law, a parolee is still regarded an applicant for admission, and the Department of Homeland Security, DHS, has the authority to revoke their parole at any moment. In the event that a parolee is turned down for an additional grant of parole, it is still highly doubtful that someone will be able to comply with the administration's present enforcement priorities. It is more likely that the Department of Homeland Security will permit aliens to have their parole extended. This would be similar to the way that the Department of Homeland Security has handled transitory protected status, which has shown to be anything but transitory.
I hope you guys found this video extremely helpful. If you know anybody that could benefit from this information, definitely make sure to share this video with them. We are all about empowering you with knowledge. So the more people that can benefit from this video, the more people we want watching this video. If you like this video, please make sure to hit that thumbs icon. Thanks for watching. And don't forget to subscribe and hit on the notification bell for more immigration updates. Bye!